This is a reconstitution of bench. Yes.
Lordship, your Lordship. Lordship, item 43, supply order matters, Lordship. May I pray for taking in this matter at 2 p.m. Lordship, we could not bring the SLP as per direction of this court, but if your Lordship take up this matter, oblige, Lordship.
May I please, your Lordship?
Just a moment. Senior to you is there.
No problem. I am not keeping well. I could not prepare 36, 37. Any date subject to Lordship's convenience, my lord. After 10 days, 1 week, any day, my lord.
Give a date after a week. Both sides are presented on the prayer made by learned transcript represented today. Let's go. 36, 37. Okay.
Objection.
Please, Lordship. For listing my IS civil, Lordship. IS civil, Lordship. Can it be day after tomorrow, Lordship? Last 30.
Give it to the court counsel, they will check the dates.
Wait, please, Lordship.
Lordship, may I briefly mention item number 15 of today's report. Lordship, in this matter, we have received the representation copy in the morning only. I have to file an additional affidavit. Lordship, may allow me some time.
Okay. Both sides are presented on the prayer made by this after.
1 week, Lordship.
This after.
Item number 10, I'm praying for adjournment, Lordship, as
Yes.
senior is.
Then
Yes, sir.
please wait till the matter is called. This is 2019 matter.
All right, Lordship.
You need to pray when the matter is called.
All right.
Please, Lordship, I beg to mention item number 21. This matter may be taken day after tomorrow, my lord.
Yeah. 21.
Oblige.
Lordship, I beg to mention item 18 for in Passover.
Item
18, Lordship.
same order. 80. Yes.
May I please,
Oblige.
Lordship, I beg to mention item number 33.
32.
Lordship, may not like to take up this matter.
This is the matter before any other bench without one of us cares.
Deeply obliged.
Daily list item 1 for motion.
May I reason? Last occasion call for report. A report should my lord.
Sunin pura de eso, sab. Dice, yo ando, my time que no va a ver Pablo. Report submitted ADC.
My lord, actually my senior is coming here, so document after some time, my lord. Page 14, 13, 14, 1385, 40.
to 14 minutes, okay, good. ধর্মত নাই ধর্মের মেটার শুরু করে আছে তো ঠিকই আছে করিল একটু দিয়া এই সময় টমেটো লইছে আমি কে বলি Pardon. Document bisa itu. Document itu. Document itu lagi. Document. Polisi.
With that report, we are remanding the matter back. They will exhibit this and this was discarded because the name is not here. Only on that ground. So now there is already a report. We are putting it as a part of order and then sending it back. This is the last learned cause for the petitioner and so and so for the respondents. Next one. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has received the opinion dated 25/2019, page 49, passed by so and so in so and so, thereby declaring the petitioner to be a foreigner who has illegally entered Assam on or after 25/9/1991. And liable to be deported. Next. In view of the order proposed to be passed, the pleadings and evidence on record are not referred to. Next, suffice to mention that on receipt of notice of the proceedings, the petitioner entered appearance before the learned tribunal. Apart from his evidence on affidavit, written statement from also filed his evidence on affidavit and exhibited 10 documents being page 50, exhibit K. No? So, the petitioner had also examined his projected mother, Malati Nag, MAL ATI, as DW2, and Shamal Nag, the uncle of the petitioner, projected uncle of the petitioner as DW3. Next. The document which was exhibited as Exhibit B is a certificate of registration in the name of Suresh Chandra, CH Chandra Nag. Whose father's name is late Mahim, M-A-H-I-M, Mahim Chandra, C-H, Chandra Nag. Was then aged 31 years and place of birth being village Saltia, S-A-L-T-I-A, P.S. Gauhar Gaon, G-A-F-F-A-R, G-A-O, district Mymensingh, M-Y-M-E-N-S-I-N-T-S, within bracket East Pakistan. And his address at the time of registration. And his present address is village Obari, O-U-B-A-R-I, P.S. district Dorong. The said certificate of registration has been issued under section 5 within bracket 1 within bracket small a bracket 2 oblique bracket D small d of the Citizenship Act 1955. The said evidence was discarded by the learned tribunal on the ground that at the top of the certificate, the column regarding name of registering authority and place was shown blank. Accordingly, it was held that it was essential for the petitioner to prove the contents of Exhibit B with primary evidence. Accordingly, on the ground that Exhibit B, being unproved, also suffered from grave doubt towards genuineness, thereby rendering the same to be wholly unreliable. Next one. In the considered opinion of the court, a certificate of registration would constitute a primary proof of registration as it is a certificate in original and given to the person who was registered as a citizen of India by registration, which is permissible under section 5 within bracket 1 within bracket small a oblique small b of the Citizenship Act 1955. The absence of the name and place of the registering authority in the present case in hand is not found to be fatal, as the rubber seal of the office, which is additional ADDL, Deputy Commissioner, Dharan, Mangalde, with a round seal of the office of the Deputy Commissioner, Dorong, is clearly visible. No faded is visible. Accordingly, by an order dated 25 to 2026, The court had requested the additional senior government advocate to obtain instructions and the court had also directed the learned counsel for the petitioner to provide a photocopy of the said document as well as hard and soft copy of the writ petition. Thus to enable the learned additional senior government advocate to obtain instructions. Next. Today when the matter was called, the learned additional senior government advocate has produced a copy of written instructions under memo number, this one, memo number so and so. Okay. Okay. First of all, it is deemed appropriate to quote this said letter to make it a part of the order. This one, huh? Next. In the further opinion of the court, if a person has been duly registered by invoking section 5 within bracket 1 within bracket small a bracket small d of the Citizenship Act, comma, the person who is registered becomes a citizen of India by virtue of registration. Next, therefore, comma. As the petitioner has been able to demonstrate that his projected father when alive was registered as a citizen by virtue of certificate of registration, bearing number 80596 dated 5/8/1967, which is found to be matching with the records which is available in the office of the additional district magistrate, Sonitpur, Taipur. The court is of the considerable opinion that the ground on which exhibit B was rejected is not sustainable. Expect accordingly, comma, the imperial opinion is found vitiated with due to error in appreciation of exhibit B. Accordingly, court is inclined to pass the following order. Number one, the imperial opinion dated so and so, page 49, is hereby set aside. Next paragraph. The petitioner, namely so and so, who is duly represented by his learned counsel, is directed to appear before the learned member, foreigners tribunal number 8, Sonitpur, Tejpur, on before 3/04/2026, and by producing a certified copy of the order with and the original certificate of registration within bracket exhibit B, Mr. Sharma and both Mr. Sharma, what should we do? Is it necessary for this document to be proved again to call for the records? It will be unnecessary. No. Not like to pay. Already, this is the original, we have already.
Yes, Lord.
And wait for further. And wait for further directions of the tribunal. Just to rehear the matter. Again, next with the directions, just main character. What is with the book? The request is partly allowed to the extent that indicated to the verb. More as it was. It's a part of the.
Item 2 for motion.
Yes.
Item 2.
Impugned has been Millard, Your Lordship may kindly annex 6 Millard, page 37 and 38. I received notice from the tribunal. I filed this statement. I deposed in the tribunal and my brother. And also sister-in-law and also one government official.
Where is your written statement?
This Millard annexer 1 page field.
And the opinion is at which page?
Opinion Millard page 37. All 2 elsewhere has come. Earlier she was declared by another member Miller as a alien, not foreigner. And by this Stephanie Miller, she has been declared as a foreigner.
Which is that other opinion?
Another one, page 55 Miller. It was exhibited Miller as exhibit 7 in the present case. Sharma. And then we try him.
Shana, this has to go back.
Yes, Doctor.
You've seen the out
Yes,
opinion.
Doctor.
You send it back. Good. Nothing wrong today. Taking up 2 cases. What are beating demanded? Let me say A. Rashid, learned counsel for the petitioner and counsel for the respondents. Next. By filing this writ petition under Article 226, the Constitution of India, the petitioner has received the opinion dated 18/4/2019, case 37, passed by so and so in case number so and so. PE number so and so, by which the petitioner was declared to be a foreigner of post 25 in 1971 city. By further holding that the petitioner had failed to discharge the burden of proof that she is not a foreigner, as mandated under Section 9 of the Foreigners Act from 1946. Next page. In view of the order that is proposed to be passed, the intent of the written statement and the evidence on affidavit tendered by the petitioner and the discussion on the evidence on affidavit by the projected brother of the petitioner, Kurban, Kurman, Ali, within bracket DW2, and Amiron, Amiron, within bracket projected sister-in-law of the petitioner, within bracket DW3, are not discussed. Next. It would suffice to mention that on appearing before the learned tribunal, the petitioner had filed a written statement and exhibited 7 documents along with the evidence on affidavit, being Number one, electoral roll of 1965 within bracket exhibit 1, electoral roll of 1970 within bracket exhibit 2, electoral roll of 1985 within bracket exhibit 3, electoral roll of 1985 within bracket exhibit 4, electoral roll of 1989 exhibit 5, certificate issued by the Gauhati, certificate dated 21/5/2016 issued by the Gauhati within bracket exhibit 6, and certified copy of opinion dated 8/12/2016, asked in respect of the petitioner in um, by the learned member of Foreigners Tribunal number 8, Kolkata, in page 55 in so-and-so, identity representing so-and-so, by which the petitioner was declared to be not a foreigner within bracket exhibit 7. Next, the learned tribunal has referred to the has briefly referred to the exhibits and its contents, and without any discussion on any of the exhibited documents, summarize the appreciation of evidence or discussion and decision as follows. Page 38, summary. 1 to 9. Next part. The petitioner had exhibited as exhibit 7 the previous opinion dated 8/12/2016, and in view of the settled thought that the principles of res judicata applies in the proceedings of the foreigners tribunals, for which the decision of the Supreme Court of India in the case of particular Supreme Court judgment, in the case of Abdul Quddus versus Union of India, 2019, within bracket 46 SCC 604. Is a is may be referred to. So we said decision of the Supreme Court of India was followed by this court in the case of Jahir Jahir Ali versus Union of India, within bracket 2021, bracket was 3 GLR 105. 105 equivalent to 2021 within bracket 2 bracket close GLT 596. Next. Under the circumstances, comma, by merely observing that on the premises no reliance can be placed on exhibit 7 is wholly unsustainable. More so, comma, as the learned tribunal, comma, on the basis of exhibit 1 and 2, the exhibit 1 has held that the presence of the petitioner's two elder brothers and sister-in-law are found in exhibit 1 and therefore they were deemed to be citizens of India under section 6 capital A within bracket 2 of the Citizenship Act, 1955. Next, accordingly, comma, the ground on which exhibit 7 was discarded is not based on correct appreciation of the facts and law relating to res judicata, as discussed in it before. Accordingly, the impugned opinion dated so-and-so, as by so-and-so, is found vitiated by incorrect appreciation of the exhibit 7. By failure on part of the learned tribunal to discuss exhibit 6 under the principles of res judicata, which is applicable, squarely applicable in the proceedings of the foreigners tribunal. Next, resultantly, comma, court is inclined to pass the following orders. Impugn order dated, impugn opinion dated 18/4/2019 within bracket. Also, in this space that is hereby set aside. Number 2, petitioner, comma, who is duly represented by a learned counsel, is directed to appear before the learned member, comma, foreigners tribunal 11. Foreigners tribunal number 11. Servo, along with a certified copy of the order on or before 3/04/2026. And wait for further orders of the state learned tribunal. In the event the petitioner fails to appear before the learned tribunal on the date fixed, the learned tribunal would be, it would be permissible for the said learned tribunal to treat the petitioner as a legal body and pass appropriate orders that will be deemed fit and proper. Next. And that the records expeditiously along with the copy of the orders to be made a part of the record. Next, the petition stands partly allowed to the extent as indicated above. It shall be no order is to
My lord, I may be allowed to see the record of item number 4. my lord.
For motion, item 3.
please, your lordship. Lordship, in opinion at page number 23, my lord. My lord, in the voter list of 1966, Nosad Ali's name is there. My lord, Nosad Ali is the grandfather of the petitioner, my lord. And in the year 1997, grandfather and father's name is there, my lord. And like that, my lord, in the year 2018, petitioner and father's name is there, my lord. At page number 22, 45, my lord.
Petition open. Yes. This is purportedly exhibit 9. Now see this flag document. Different document. The reason is, you look at the exhibited document, the certificate copy is produced on which date? Exhibited document?
Date of issue is to 18/5/2018.
18/5/2018. Now look at this.
26/3/2019.
This is after opinion. So in this, you are The other two people are not there.
Only 534 is there.
So you missed the link. And now before us, you produce this document. Now you'll have to tell us how will we deal with you. This document, page 41, is procured after the opinion.
My lord, I have filed one additional affidavit, my lord. It is there in the record, my lord. The exhibited documents, my lord.
Okay. Okay. Once you have got it on record, we don't say anything. But then you miss out on evidence that was not proved. Because then you don't have a link with your father, projected father. Exhibit 7, the school certificate, the author was not examined.
My lord, when Gambura certificate was there, he was adduced evidence, my lord, as GW2, my lord.
That is certificate of 17/4/2018. The document is at which page?
Number 51.
51. So this becomes inadmissible. That's why you lose the link. And what is an explanation in your writ petition as to why the petitioner could not file an affidavit, why his father is filing an affidavit? What is the reason? What is his disability which prevents him from filing the affidavit?
My lord, he was sent to detention camp on the same day, my lord.
Is it? Where is that statement?
My lord, we have filed one IA also, my lord.
Shows the IA. Okay. Okay, you have that explanation. He was taken into custody. Then, madam, you lose your link. How are you sustaining that link?
My lord, then give me 1 week time, my lord. I will try to satisfy your lordship on the next date, my lord.
1 week time.
My lord.
Okay, both sides are represented on the prayer made by non-counsel for the petition. Please stop. Give a date after a week.
Twenty-fifth of March.
Good lord.
Next time, please remind us
My lord.
that this document has been referred to in the affidavit. But this will, you'll find that question every time it comes.
My lord.
Item 4 for motion.
May it please the lordships. My lord,
Do you have an original of that exhibit 1?
my lord, original, my lord, is taken by the client, my lord. It's the
No, you have to see the original, not the.
photocopy of the original, my lord.
No, this will not do. Original, you have to see the original.
Original. My lord, the original has been taken by the client, my lord. The original photo, colored photocopy is there, my lord. My lord, that exhibit 1 is not disputed by the tribunal, my lord. Not the state as well as the tribunal also, my lord. Is not disputed. Only thing is that, my lord, this exhibit 1 is rejected only because it is stated in the judgment that it is not proved as per law. That finding is page 53, last page, my lord, first paragraph, last line. And this document, my lord, issued in 1960. So it is 30 years old documents, my lord, under Evidence Act section 19 of the Evidence Act. Presumption can be drawn, my lord, that it is genuine, since it was produced from the proper custody, my lord, of the son of the deceased, my lord. Radhacharan Pal.
No, you lose here. With that argument, you lose, tend to lose. The reason is that the petitioner did not come and give evidence. It is the witness box was his to other people. Petitioner did not give evidence.
And moreover, it is admitted fact, my lord, that the petitioner's father came from East Pakistan, my lord.
What prevents
And
you-
thereafter, he has registered himself in 1960. So, my lord, in support of this, my lord, I have one decision of this honorable court, my lord, which similarly, my lord, situated documents was considered by this honorable court, my lord, and it is held that 90 years old documents need not be proved under the evidence of section 90 of Evidence Act, my lord. That citation, my lord, Uttam Shaha, my lord. Two 2022 4 ZLT, page 4 to 6. Uttam Ghosh versus Union of India and others. I am similarly situated, my lord, in that case. 2022 4 ZLT, page 4 to 6.
2022,
4 ZLT, page 4 to 6. Same question arises, my lord, whether this to be proved or not. Paragraphs, my lord, 34, 36,
Don't even
39,
have to-
40.
we don't even have to look there
My lord.
because you did not give evidence.
My lord, these documents has been exhibited, my lord.
No,
Exhibited, my lord, that is no evidence, but it, from the judgment itself, my lord, they reflected that. Orally, my lord, produced perhaps, my lord, that is, though evidence has not been read, but it is in the court itself, my lord. My lord, page 51, my lord, of the judgment. I have opinion, my lord.
The document. We are looking at the document, the matter of setting at the record. You'll see it from exhibit, page 43 onwards. And the problem is that you don't even say in your petition that the that you're not given proper advice. Last part, page 43 onwards. First, look at the last page. First, look at the last page of the record. This is how the last page. This is how the evidence was introduced. Now look at the, now turn pages one by one. You will find 9 exhibits. Yes, none of them signed. There is no evidence on record. What the tribunal does is ask few questions.
Yes. So directly, my lord, he has produced the, before the court, my lord.
We don't know. We don't
And
know.
that was also recorded, my lord, as exhibits, my lord. Since he has produced the original, my lord, before the court.
But there's no signature of the, in none of the exhibited document is the signature of the member.
My lord, these are all photostat copies. Oh, no. Case number. Period in original. My lord, some, huh?
That's why
No
we wanted
signature,
to-
yes.
That's why we wanted to see the original exhibit 1.
My lord, sometime maybe again, I will communicate with the petitioner, my lord, for original. I will produce.
You see, that's why it fails because of the fact that the none of the exhibited documents are produced from the custody, and therefore section, what do you call that? Petition document is section C. What is that provision? 50,
Section 90,
19,
90,
the Evidence Act,
yes,
90.
90.
That doesn't apply.
Others documents, my lord, except this, other documents I have the original certificate document,
In fact, that's why I sent you the records. Not
My
the
lord.
documents is true.
my lord. I can bring it, my lord. But sometime maybe.
So you are represented. The chair made by Mr. P.C. Dev and counsel for the petition, the matter is done today. This is.
My lord,
This when
after a month, my lord, because of no communication with me for a long time.
April.
Item 5.
May I please, your lordship? Lordship, your lordship will find the impugned opinion at page, my lord, 49, annexure 8, my lord. My lord, before I start the merit of the, my lord.
But my lord, this is the case, my lord, where my lord tribunal has passed the opinion, my lord, beyond the reference, my lord. Beyond the term of the reference, my lord. Your lordship, my lord, the reference was initiated, my lord, suspecting the petitioner, my lord, to be an illegal migrant, my lord, who entered India between, my lord, 1966 to 1971. But the tribunal passed the opinion, my lord, declaring her to be a foreigner post 1971, my lord. Santosh Das, my lord. My lord. Rukia Begum, my lord. My lord, that Rukia's judgment, my lord, is completely different, my lord. In that case, my lord, the reference was, my lord, returned back, my lord, by the tribunal, my lord. That's why, my lord, the principle of res judicata applies, my lord, in that case. Learned, my lord, this honorable court has discussed the stare decisis and the, my lord, par inquiry. Principle of, my lord, doctrine of par inquiry. Even in the, my lord, inquiry report form 3, my lord, your lordship will find in column number 18, my lord, the inquiry officer, my lord, clearly stated that the petitioner entered into India after 1/1/66. My lord. Yes. But in column number 18 of form 3, my lord. After 66. No, I'm still mentioning, my lord, column number 18 of form 3, my lord, of the inquiry report, my lord. There is two column, my lord, A and B, my lord. B, my lord. Yes, my lord, that is there, my lord. Yes, ma'am. My lord.
Whether you were born after what you call, 1900? Answer would be yes.
My lord.
So that would not mean that the answer to question of the date of birth is wrong. And birth in 1970, a question is asked whether born after 1900, after 19th century. I'll say yes.
My lord, since the, my lord, references of my lord 66, 71, my lord, the petitioner also, my lord, adduced evidence in that manner, my lord, before the trial court, my lord.
So then also there is two flaw in your, there is one flaw in your written statement. In your written statement, you project birth, she was born in 1965. That means definite year is there. And then you again say that in 85, she casted vote.
Yes, ma'am.
If
After
85
marriage.
is 20, 20 would not be the year of franchise then, because in 89 only it was reduced to 18.
Yes, my lord. After 1981, my lord, it was reduced to, my lord, 18.
So at that point of time, 85, there could not have been a right of franchise. Because you have given a date of birth, year of birth.
Actually, my lord, so far, my lord, the voter list is concerned, my lord, she did not exhibited some other documents, my lord, other voter list. My lord, the petitioner has supplied to me, my lord. In the year 1989, she has casted vote, my lord. Because, my lord, in 1985, my lord, probably there was no election. It is heavy, you know, 83 to. But in the year 89, my lord, she has casted vote.
Because you see, the only way to, so you are connecting yourself to your projected father,
My lord.
is that you are showing your father to be a voter in the year 1965 and 1970.
Yes, my lord.
And then you have a link document exhibit 4.
4, my lord.
That goes because of the impression of the state emblem.
Yes, my lord. So for the other exhibit, my lord, voter list, my lord, 66 and 70, my lord, the learned trial court, my lord, did not explain, my lord, why these two documents were discarded, my lord.
Which one?
Voter list of 1965 and 70, my lord.
It's not a family member. We don't know how to link you to your
My lord.
projected parents. You see, Mr. Lakar, these names are very, very common.
Yes.
That is why so much of scrutiny. Otherwise, it would not have made this such so much of scrutiny. Then what has happened, you were cross-examined.
My lord.
In the cross-examination, you introduced your brothers and sisters.
Yes, my
But
lord.
there's notice of none along with the family members.
Because, my lord, my reference was, my lord, 6670. According to the petitioner, my lord, she has to produce, my lord, voter list linkage of prior to, my lord, 66. She has to establish that she is a Indian citizen, my lord, and born to an Indian parents whose domicile was existed, my lord, in India prior to 66. That document she has to produce, my lord. In WS, my lord, she has stated all material facts, my lord. Date of birth, my lord, parents, name also mentioned, my lord. So far, the brother and sister are concerned, my lord, she mentioned in her evidence, my lord. Document to refer distinguished to larger than should pick up Students must then comply to discipline of requesting the emergency procedural larger games. Detail coordinate venture another area. Detail larger than should pick up. This is very foreign.
Sharma, in this case, Mr. Letter appears to be correct. In the written statement, the defense was taken with regard to 1166 to 25 371, and that is how it proceeded. But the tribunal gave the opinion on 2A. Tribunal is right. But in view of the constant stand in the evidence and in the written statement about this, we think that this is a case where it should be remanded back so that they can take an adequate defense. If it is to be determined under 2A, so we say that and we'll send the remand it back so that he gets an opportunity to for the defense, because we have checked the written statement. In the statement also in the first page, last paragraph, he gives the sense of 1166. In that statement, it takes that difference. In the evidence also, that difference is there. When it comes to the question of prejudice, in view of the law laid down in that Rukia Begum, that reference can only be to a matter of fact given authentic to the petitioner. But he gives a, your SP gives a different demand. As well as so for the respondent. Next one. By filing this repetition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 27/5/2019, page 49, passed by so and so, FT case number so and so, SP reference case number so and so, by which the petitioner was declared to be a foreigner, of course 25 to 1971 street. Next para, in view of the nature of order which is proposed to be passed, comma, the stand taken by the petitioner in the written statement and in the evidence of the petitioner as DW1, comma, Ganesh Muro, within bracket exhibit PW2, sorry, DW2. There are only two witnesses.
Two witnesses.
Have not been referred to. Next one, I could suffice to mention that although as per the inquiry report in Form 1, Roman 1, Form Roman 2, and Form Roman 3, comma, the recommendation of the Superintendent of Police was to the effect that the petitioner is a foreigner who entered into India illegally, comma, but in the forwarding report, no, in the forwarding of the reference under section 2, within bracket 1, within bracket A, you say within bracket SIC, full stop, ought to have been 2(1)B. Section 2(1)B of the Citizenship Act, 1955, bracket closed. It has been mentioned that the petitioner has entered into Assam after 1/1/1966 and before 25/3/1971 illegally. Next part. In the aforesaid context, the learned counsel for the petitioner has referred to the stand taken in the written statement and in the evidence on affidavit by the petitioner to project that the specific defense taken by the petitioner related to the period between 1/1/1966 and before 25/3/1971. Accordingly, it is submitted that the learned tribunal had decided the reference contrary to the reference made which, according to him is not sustainable in view of the law laid down in the case of
Rukia,
So Rukia is different. Rukia says yes.
yes,
Where everyone is
Santosh Das,
in the so us versus
Union of India,
others. What is the citation?
2017
2017
to
within bracket 2
GLT
GLT
1065.
1065. Next question. Per contra, the said issue, the learned standing counsel for the FT and border matters has submitted that in the subsequent decision in the case of Rukia, RUKIA, Rukia Begum, DEGUM, Bordmia, VARBHUIYA, alias Rukia Begum versus Union of India and others, 2023, within bracket 4, bracket GLT 1208. This the coordinate bench of this court had laid down the point of law that Rule 2 within bracket 1, bracket close of the foreigners within bracket tribunals, bracket close order from 1964 makes it discernible that central government may, by order, refer question as to whether a person is or is not a foreigner within the meaning of Foreigners Act of 1946 to a tribunal constituted for the purpose to stop. In the said decision, reference is made to the decision of this court in the case of Falani BV versus Union of India and others, WPC 7104 of 2015, decided on 18/8/2017, wherein under the same fact situation where the reference accused the petitioner therein for coming into Assam between 1/1/1966 to 24/3/1971, but the tribunal had held the petitioner to be a foreigner of post 25/3/1971 stream. This court, by referring to section 2 within bracket within bracket 1 within bracket here now, we're referring to section 2A of the Foreigners Act, where a foreigner is defined to mean a person who is not a citizen of India, had held that the statutory provision of clause 2 within bracket 1 of the foreigners within bracket tribunals bracket post order from 1964, any reference will have to be understood to be a reference to the tribunal on a question whether the person so referred is a foreigner or not within the meaning of Foreigners Act from 1946. Where again a foreigner is given the meaning of a person who is not a citizen, and whereas citizen is defined under the Citizenship Act of 1955. Accordingly, it is submitted that the reference can only be answered as to whether the petitioner in this case was a foreigner or not. Next one. In view of the law as laid down by this court in the case of Rukia Begum versus Union of India, Rukia Begum Barvina, alias Rukia Begum within bracket Supra. Is found to be correct and appropriate in view of the definition of a foreigner contained in section 2 within bracket A of the Foreigners Act from 1946. This court cannot take any view other than what has been laid down in the case of Rukia Begum or alias Rukia Begum within bracket Supra, to the effect that a reference can only be answered as to whether or not a person is a foreigner. Next. However, notwithstanding the decision of the learned tribunal, the court is of the considered opinion that the submission made by the learned counsel for the petitioner that the entire defense of the petitioner is based on the nature of reference that the petitioner is a foreigner, was entered into India between 1/1/1966 and 24/3/1971. And accordingly, the evidence is also led with that view. The court is of the considered opinion that the petitioner has been, that in view of the submissions made by the learned counsel for the petitioner, the petitioner has been able to make out a case that she has suffered prejudice of limiting her defense for the period between 1/1966 and prior to 25/1971. Accordingly, the court is of the further considered opinion that the petitioners deserve to be given an opportunity for taking an appropriate defense with regard to the question as to whether the petitioner is or not a foreigner, as defined under section 2 within bracket A of the Foreigners Act from 1946. Next, accordingly, without finding fault with the impugned opinion, dated 27/5/2019 within that page 49, the said opinion is hereby set aside so as to enable the petitioner to take an appropriate defense in a written statement by filing an additional written statement before the learned tribunal with liberty to adduce further evidence, if so required, public desire. Next, accordingly, the court is inclined to pass the following order. Subparagraph A, that the impugned opinion, page 49, is hereby set aside. Next, the matter is remanded back to the said learned, to the learned foreigners tribunal, Baksa, Tambulpur, for giving an opportunity to the petitioner to submit a written statement, additional written statement, and thereafter to reduce further evidence, if so advised. Next, the petitioner who is duly represented by learned counsel is directed to appear before the said learned tribunal on or before 30/4/2026, and by producing a certified copy of the order, also file her additional written statement and await for further orders of the said learned tribunal. Next paragraph is further clarified that if the petitioner fails to appear within the time allowed, it could be open to the said learned tribunal to treat the petitioner as absent on call and pass such appropriate order as deemed fit and proper. Next paragraph. The main paragraph now. the registry to send back to return back the fabulous records expeditiously. Next part. The request has partly allowed to the extent is indicated below. But you know our best to
Tribunal shall complete the proceeding as per
in this subparagraph, you also write, the learned tribunal shall make an endeavor to dispose of the matter within the time as permitted under section
14 bracket 14.
within bracket 14 of the
For an tribunal order.
ordinance within bracket tribunals, practice order, 1964.
March order.
Item 6.
Please, Your Lordship, Miller. The petitioner's Millet Umar Ali Millet, his father is Millet Hormuz Ali Millet. Grandfather is Yasmin Millet. The assurance certificate Millet, page 19 Millet, exhibit A Millet. The contents were proved. Is a resident of village Millet Balidunga Pump. Opinion is at page. Millet, the Gaubura certificate is at page. Opinion Millet. Opinion is at page Millet. 50 Millet, 50 Millet, next of 13. 50. 50. But I'm compared to smile in this case. The reason is that prior to exhibiting of the land document, your father is, last name is Fakir. But after purchasing of land, he becomes Sarkar. Millard, with all respect, Millard, I have seen in many documents. No, that's okay. I'm saying that I'm not commenting on anything. I'm saying that we are compared to smile. That these are the Millard, common Millard type of Millard. Some surnames were given. How Fakir can transform into Sarkar? Yes, Millard. Somebody did it. Smiling on that. Someone is also Millard. Someone's name is also written as Sheikh Millard, somewhere Millard. No, we don't know in the documents that we are not commenting on evidence. Doesn't appear Millard. Please don't take it that we are commenting on the evidence. We are just compelled to smile. I understand. Yes. The linkage is there, Milord, in this case, Milord, along with the petitioner and the Milord, his father and grandfather, Milord. All of them, Milord, there is no shifting, Milord. They belong to the same particular village, Milord. The only thing is that, Milord, while producing and exhibiting the voter list of the petitioner, Milord, the first voter list of the petitioner was 2005, Milord, exhibit F, page 27. In that particular voter list, Milord, the petitioner's name was not enlisted along with his father as well as with his mother, Milord. Maybe, Milord. But that is not the Milord observation of the tribunal, Milord. But his father's name is there all along, Milord, from the same village, Milord. If we compare to, Milord, the voters list of 1970 and 66, Milord. Same village, Milord. And the Gaugura certificate is also, Milord,
was also proved by the concerned Gauhati. But it was categorically mentioned that Gauhati cannot issue this kind of certificate. Actually, this is an identity certificate. The learned member said that it was issued during the continuation of the proceeding. But we have seen in all the cases, where a Gauhati certificate is exhibited or produced. Now, moment it is required only, then only the person concerned gets a certificate from the government. Ballot.
Yes, please continue.
Yes, my lord. I'm also relying on the, my lord, the Gauhati certificate, annexure 1, page 19. Page 20 is the vernacular that was exhibited as exhibit A, my lord. And the contents of the certificate was also approved, my lord. If my lord considers, my lord, the age of Gauhati was then, my lord, 42 years old. And this man, who belongs to the same village, my lord, he was 35 years old. Meaning thereby, my lord, they were contemporary. He must have the personal knowledge, my lord, regarding the residential status and the identity of this man, my lord. If you try to connect, my lord, along with the, my lord, voter list of, my lord, 1966, which is the voter list of,
Hormuz and Sahiron.
my lord,
Hormuz and Sahiron.
Hormuz and, yes, Hormuz and Mahiran Nasa.
Hmm?
Hormuz and Mahiran Nasa. Mahira. Mahiran Nasa is the mother. By virtue of these two voter lists, 66 and 70, we can connect with this, my lord, petitioner, my lord, his linkage and lineage with his father. Yes, I admit that, my lord, the parent's name did not reflect in the voter list of 2005, but he did not mention anywhere when did his father die, my lord, his parents died, my lord. And the name of village and as well as the name, my lord, it reflects to that same name, my lord, from the same village. Land documents are also there, my lord. Probably the father is alive, my lord, therefore, my lord. He did not inherit, my lord, land from his father. Annexure 5, page 29, my lord. Handwritten on the government. The name of father was enlisted at serial number 5, my lord, Hormuz Ali, Ita Yasin, page 29, annexure 5. As Patazar. Grandfather's name is also rightly mentioned as Yasin. The certificate in this regard is also issued by the sub-deputy collector of the tribunal circle, my lord. Page 33, annexure 7, my lord. This was also issued in favor of the father of the petitioner. Wherein, my lord, the name of the father has been mentioned as Hormuz Ali Fakir. Fakir has been added, my lord. That the common mistake that we see, my lord. But the name, my lord, Dag number and Patta number remains same if we compare it to the Javabandi copy, my lord, annexure 5. Annexure 7 and annexure 5, my lord, if your lordship kindly compares, my lord. Patta number is 132 and Dag number is 231. Remains same. One certificate, my lord, pilgrim plus certificate, my lord. That I could not, my lord, annex, my lord, along with the writ petition, my lord. This was exhibited as Exhibit E, my lord. It was issued on 1/5/1960, my lord. In favor of my grandfather, my lord, Yasin Ali, my lord. It's a very old document, my lord. Certainly it is in the record, my lord. Exhibit E, my lord.
Exhibit E.
Yes, my lord.
What is that?
That is a, my lord, Pilgrim Plus certificate, my lord, copy of Pilgrim Plus, which was issued on 1st of May 1960, my lord. It may be in the record, my lord, of my grandfather. The linkage seems to be very clear, my lord, right from my lord 1960. Exhibit I and J, my lord, if these two documents are, my lord, may kindly be compared, my lord. The pata number and dag number remains same. However, my lord, in the name of my lord, along with the name of father, my lord, Fakir has been added, my lord. The address, the dag number, pata number and village remains same, my lord. Exhibit there and exhibit. This, my lord, the Chitra copy, my lord, exhibit probably I, my lord. Exhibit I. Chitra of, my lord, 1964 and 65. Chitra copy. Exhibit E, my lord, has been written as Pilgrim Pass, my lord. Pilgrim Pass. My lord. Pass. Yes, my lord. Page 53, my lord. Regarding the, my lord, Exhibit E, my lord, which has been observed by the member of the tribunal. My lord. The first line, my lord, top. The document Exhibit E is the copy of Pilgrim Pass issued on 1/5/1960 for pilgrims. Proceed for Hejaz. The proceeding claims that it is that of his grandfather Yasin Ali. What's Pilgrim Pass, my lord? It is.
Well, I beg to mention item number 7, my lord. I want to take time because 7 and 8 two petitioner, item number 8 petitioner was died, my lord. Certificate, death certificate not yet received. And TCR is before the lordship, my lord. And we are item number 7, I'm in bail.
Item number 8, person has died.
Died, my lord, but death certificate not yet received. So, my lord, give another date after Eid, my lord.
Just ask someone to be here. We'll pass orders when we reach there.
My lord.
Ask someone to be here.
My lord.
Ask someone to be here to make a mention. We'll adjourn it. Yes.
Yes, my lord. Exhibit I and Exhibit J, my lord. These are both land documents. My lord. Exhibit I is the cheetah copy of the petitioner's father, my lord, pertaining to the year 1964 and 65. And Exhibit J is also a landholding certificate, my lord, issued by the sub-deputy collector, SDC. But in the Exhibit J, my lord, his father's name, my lord, along with his father's name, one fakir has been added, my lord. That I have also annexed, my lord, in the petition. Page 29 is the cheetah copy, my lord. So far as, my lord, I have annexed, my lord, it doesn't show the year. Probably it is in the TCR, my lord, because the learned member has rightly stated that it was pertaining to the year 1964 and 65. He has mentioned it, my lord, in the final, my lord, ordinance. Page 53, my lord, second last paragraph of the imperial ordinance. Yes, my lord. There is another, my lord, land revenue paying receipt, my lord, which was paid by the father of the petitioner on 21st of May 1966. My lord will find at page 32, my lord, annexure 6. That was executed as exhibit K, my lord. Out of the same land, my lord. Hormuz Ali, my lord. Here, Sarkar has been added, my lord. Same person, my lord. My linkage with my father, my lord, can be established, my lord, by virtue of this voter list of 2005, page 27, my lord, and the one certificate, identification certificate. Hormuz Ali, my lord. Abdul Kalam, Kalam, my lord, Kalam. My lord. Now, my lord will kindly come to my lord, page 27 for a moment, my lord. This is my first voter list which I produced before the concerned tribunal. my lord. Voter list of 2000. Page 27, 2005 voter list. my lord. My name appeared at serial number 530 Samar Ali. Father is Hormuz Ali. He's from same village, Palidunga Palm. my lord. In the same police station. my lord. And regarding this voter list, my lord, the learned member has indirectly my lord, accepted that this is the voter list pertaining to, it is in my favor, my lord, but it can't be a conclusive proof of citizenship. He has said, my lord. My lord. So far as, my lord, my linkage with my father Hormuz Ali is concerned, my lord, this is the, my lord, voter list of 2005 and the Gauhati certificate and the deposition made on behalf of me, my lord, by the concerned Gauhati. These are the, my lord, documents, my lord, that I am produced, my lord, before your lordship, my lord, by virtue of which, my lord, the linkage and lineage along with his father is absolutely clear, my lord. The basis of, my lord, the concerned Gauhati certificate, my lord, which was exhibited as exhibit A, my lord. This exhibit A, exhibit F, in the deposition made by the Gauhati. Exhibit F is the voter list of 2005 of the petition.
Which document? Voter list.
The voter list, my lord, 2005. my lord.
Voter list of 2005.
Yes, my lord, of the petitioner, my lord. And if it is compared with the voter list of 1966 and 70 of his father, my lord, the linkage is very clear, my lord. And in fact, my lord, the learned member has said at page 53 also, my lord. Last
No,
paragraph.
just give the link of documents, then you make your submission.
My lord.
Only two documents, Exhibit A and Exhibit F.
Exhibit A and Exhibit F are my linkage document with my father. my lord. The rest of the documents, my lord, belongs to my father. my lord.
Okay.
There was another document, my lord, which was discarded because of using the, my lord, state emblem, my lord. Annexure 2, my lord. The Gaon Panchayat certificate. That was discarded, Exhibit B, my lord.
He did not come. Yes.
Yes. Therefore, I'm not pressing that. The other land documents, my lord, belongs to my father, my lord. Where, my lord, the name of my father was also, my lord, although, my lord, some Sarkar or Fakir was added, my lord, but he remains the same person, my lord. If it is compared to the dag number and pata number and the area of. Now, if we go by the impugn order, my lord, regarding the, my lord, Exhibit A, my lord, the learned member has said that this was obtained during the continuation of the proceeding, the Gauhati certificate, my lord. There cannot be a bar, my lord. The moment it will be required, my lord, this will be obtained by the person concerned. You know, there may not be a bar, my lord. whenever it will be required by a person concerned to produce, my lord, somebody may not have some other documents, my lord. Suppose it is required, my lord, to identify him that this man belongs to my lot or area, my lord. The governor may issue one certificate, identification certificate, my lord. Merely saying that, my lord, during the continuation of a proceeding, this certificate, my lord, should not be, my lord, issued, my lord, therefore it cannot be accepted as the certificate, my lord. But this can't do, my lord. The member has said that this was issued during the continuation of the proceeding, just to show the linkage, my lord, with his father Hormuz Ali from same village. Although the contents were also proved, my lord, there was no state emblem, my lord. The certificate, my lord, was issued without having the, my lord, state emblem, my lord. And regarding, my lord, my linkage with my father, another, my lord, document was Exhibit F, my lord. Regarding this Exhibit F, my lord, the Lordon member has said that this is a certified copy of voter list of 2005, and the proceeding claims that it is his voter list. Recording of name in the voter list by itself is not a conclusive proof of citizenship unless linked to pre-1971 is established. So my humble prayer before your lordship is that, my lord, my linkage with my father before 1971, my lord, are the, my lord, other two numbers of voter list, my lord, which belongs to same village, my lord, from the same village, Balidunga itself, where my father's name appeared, my lord. If we go back to the, my lord, voter list of 1966, vernacular at page 923, my lord. Same Hormuz Ali, my lord, from same Balidunga, my lord, same village, along with one Mahiran Nessa, who is my mother, my lord. In the 17th voter list, my lord, only the name of father was shown to be reflected, my lord. Hormuz Ali.
In this repetition, have you given the date or year when your father expired? No.
My lord, it is not, my lord, till when it was filed, my lord, father, there is no instruction that father is alive or dead, my lord. Father was alive, my lord, then, till then. Since the father was alive, therefore, my lord, the petitioner could not probably, my lord, inherit the land from his father. In the land records, my lord, the name of the father was only, my lord, reflected.
Okay.
Apart from my, my lord, deposition, my lord, another, my lord, person, my lord, who happens to be my father-in-law, not pressing on that, my lord. He has also, my lord, filed his, my lord, evidence, my lord, by way of an affidavit. My lord. Page 46, annexure 11, my lord. In the deposition of Gauhati, page 48, my lord. Annexure 12.
Which is the voters list where your father's name last appeared?
My lord, the exhibited voter list, my lord, 1970, my lord. From the exhibited case records that I have, my lord, annex, my lord, page 25, my lord. Not today, my lord, but so far as, my lord, these two documents are there, my lord, I could not take preparation, my lord, exactly. If necessary, I'll furnish it before your lordship. But what I'm praying before your lordship is that, my lord, since there is no dispute, there is no discrepancy regarding my 2005 voter list, and if it is compared to, my lord, 1966 voter list and 1970 voter list of my father, my lord, those three voter lists, my lord, belongs to same area, and it clearly identifies, my lord, shows the identity of my father and myself, my lord, and clearly establishes the relationship and linkage, my lord. Therefore, my lord, it should have been taken into consideration by the concerned member, my lord. My lord will be pleased to, my lord, remand back the matter with a direction, my lord, to consider these two documents, my lord. Exhibit A, my lord, that is the Gauhati certificate, and on the Exhibit F, my lord, the voter list of 2005, along with the, my lord, Exhibit G and Exhibit, my lord, H, my lord, the 1966 voter list and 1970 voter list, which, my lord, I am referring, my lord, to establish my lineage and linkage with my father and also with my mother, my lord. My lord. I'm diplomat.
Okay. No, nothing at first now. I'm coming to the WS lordship. If we see the WS lordship, WS is totally vague lordship. There totally lack of material facts, lordship. Lordship and what lordship? Settle law is that lordship. One cannot go beyond pleadings, lordship. 2017 4 GLT 346, lordship. 2017 4 GLT 346.
Name of the parties?
Rosminara Begum, RASHMINARA, BGUM.
With this addition?
2017 4 GLT 346. Para 25 and 27 I am reading, lordship.
You don't read?
Yeah. So, lordship, in written statement is the basic statement of defense of a proceeding before the Foreigners Tribunal. Keeping in mind of the mandate of Section 9 of the Foreigners Act 1946, it is incumbent upon the proceedee to disclose at the first instance itself, that is, in his written statement, all the relevant facts, especially within his knowledge, having the material bearing on his claim to citizenship of India. Material facts pleaded in the written statement are thereafter required to be proved by adducing cogent and reliable evidence. It is also tried that a party cannot traverse beyond pleadings made in the written statement. So, lordship, if we see the written statement, lordship, mother's name is not mentioned, lordship. His date of birth is also not mentioned. If they are alive or not, well, if died when they died, lordship, all these things are not mentioned. And if we see, lordship,
after 1970, Lordship, 1970 to 2005, Lordship, there is a gap of 35 years. What happened to them, Lordship, within this period, Lordship, this was also not mentioned. So, and 1970 to 2005, Lordship, there is a gap of 35 years. So, Lordship, there is a lack of continuity, Lordship, which is very much essential to prove one's citizenship as per Section 682 of the Citizenship Act. Then, Lordship, only thing here is to Lordship, proceeding has to establish his link with the person whose name reflected in the 1965 voter list. If we see the link document, Lordship, Gaubura certificate is there, and only one voter list, 2005 voter list is there. Nothing apart from that, Lordship. So, Gaubura certificate, I have gone through the evidence, Lordship, evidence of Gaubura. Lordship, there is a specific statement of Gaubura that, Lordship, moi jonamote, somer opor more elakar basinda hoy. That must, so what certificate issued by the Gaubura is based on personal knowledge, Lordship. So it cannot be accepted, Lordship, as a valid evidence, Lordship. So, Lordship, regarding that, Lordship, 2018 4 GLT 373, I am
First,
relying.
give the name of the parties.
ROMILA, Romila Khatun, KHATUN.
And the citation.
2018 4 GLT 373. WPC number is 3807 of 2016. Para 2022, Lordship.
One second.
Lordship, in that case, I am relying para 22. That was, that law was settled in respect of Gaura's certificate, Lordship. It is tried that documentary evidence would have to be proved on the basis of the record, and the contemporaneous record must substantiate and prove the contents of the document. Proof of document is one thing and proof of content is another. Not only the document would have to be proved, but its contents would also have to be proved. That apart, the truthfulness of the contents of the document would also have to be established from the record. A document or the documents of a document or the contents of the document cannot be proved on the basis of a personal knowledge. So, Lordship, that from Gaura's evidence, it was seen that Lordship, that certificate was issued on the basis of personal knowledge. Then, Lordship, coming to the voter list of 2005, Lordship, where his name first time reflected at the age of 25 years. And connected person name is shown as Hormuz Ali. So, Lordship, regarding voter list, Lordship, Aziz Mia's case, I am relying, Lordship, I am frequently relying this case, Lordship. Para 14, Lordship. We are constrained to observe that 2023 4 GLT 246. 2023 4 GLT 246. WBC number 2370 of 2023. Para 14. We are constrained to observe that mere claim by a suspected person by referring to a voter's list, claiming a person therein to be his father is not a conclusive proof, and that by doing so the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voter's list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable in law. So, Lordship, in this case, petitioner could not able to substantiate by adducing further materials by which he can establish that the Hormuz Ali is actually his father of the petitioner, Lordship. So, Lordship, if this voter list and this Gaura certificate goes, nothing will remain to establish his link with his projected father. And Lordship, another aspect is that, Lordship, what land document is relying, Lordship? Page 33. Here, Lordship, during inquiry, it is found that a portion of 20/5 lesa land out of 7 kotha land bearing that number so of 33, page 33. Lordship, conclusion is that Lordship, Sub Deputy Collector has issued the certificate by saying that Muhammad Hormuz Ali Fakir, during inquiry, it is found that a portion of 20/5 acres of land out of 7 kotha land bearing DAG number 230, Miadipata 132, Balidunga, Kismat of Uragaon Muza is there in the name of Muhammad Hormuz Ali Fakir. Yes, yes, perfect. Yes, perfect. Yes. Yes, Lordship. So, Lordship, what in vernacular, what it has said, Lordship, তেখেত এজন প্ৰকৃত খেতিয়ক বুলি প্ৰমাণ পোৱা গ'ল। So, Lordship, it is a proof that the person concerned is a farmer. My lord, this certificate cannot, by educing this certificate, one cannot claim his citizenship, Lordship. So, Lordship, although this certificate in the name of projected father of the petitioner. And if we consider the age of the petitioner, Lordship, he was sometimes born in the year 1980. If we see in the affidavit, Lordship, and first voter list of his projected father, 1966, is 45 years of Hormuz Ali. So sometimes he is born in the year of 1921. So, Lordship, age difference between father and son, if we consider this age, Lordship, age difference between father and son is, Lordship, near about 60 years, and age difference between mother and son is 50 years, Lordship. I don't know, Lordship, it can happen or not, Lordship. So, Lordship, ultimately, Lordship, if we ignore all these things, Lordship, then also, Lordship, petitioner is Ramjit Raghav. Lordship. So, Lordship, if we ignore all these things also, Lordship, then also petitioner is not able to establish his link with his projected father, Lordship, whose name enlisted in the voter list of 1966, Lordship.
May I, my lord, briefly submit to his submissions, the reply to his submissions. My lord, very briefly, I will submit before your lordship, my lord. Regarding the, my lord, WS, my lord, this is a statement. My lord, this is a, by virtue of furnishing or submitting the WS, my lord, the proceeding, my lord, initially, my lord, discharges its burden, my lord. This is the process of discharging the initial burden of the proceeding, my lord. In the WS, my lord, nowhere it is mentioned that I'll submit this, I'll exhibit this kind of documents, my lord. The time only comes, my lord, at the time of adducing evidence, my lord. What are the, my lord, exhibited documents which were produced, my lord, before the concerned tribunal? And on the basis of those documents, my lord, whether this has been lawfully discussed or appreciated or discarded lawfully, my lord. Those things will be taken into consideration by my lordship, my lord. Now, coming back to the voter list of 2005, my lord, my learned friend has submitted, my lord, that I should also substantiate along with this voter list, and regarding my linkage and lineage with my father, I need to show, my lord, that how come this man is related to me, my lord. The man whom I have claimed to be my father, my lord, Hormuz Ali, how he is related to me, my lord. As I have already submitted before your lordship, my lord, that by virtue of 1966 and 70 voter list, my lord, it is absolutely, my lord, very transparent and clear, my lord, that this man is my father, my lord, Hormuz Ali, my lord. And there is no, my lord, dispute, my lord, regarding this part, my lord. The tribunal has never said anything, my lord, that I have projected this man and this man is, my Hormuz Ali is not my father, my lord. He has never said like that. And regarding the, my lord, exhibit A, my lord, the Gauhati certificate, my lord. Even if the certificate was not exhibited before the, my lord, concerned tribunal, merely by virtue of the, my lord, oral deposition, my lord, somebody who is contemporary to my age, my lord, and if I belong to his area, my lord, or lot, my lord, and if he is a Gaupura, my lord, he must have the personal knowledge regarding the inhabitants of his area, my lord. I am an inhabitant of his area, my lord. Even the certificate itself is discarded, my lord, by virtue of, my lord, his oral deposition, my lord. Is it not sufficient, my lord, that he has a personal knowledge regarding my, my lord, existence, my lord, my relationship with him, my lord, since he knows me personally, my lord. I belong to his area, my lord. Therefore, my lord, and by virtue of the, my lord, this exhibit J and exhibit I, my lord, these land documents, I'm not trying to, my lord, establish the citizenship right. These are the land documents. Had it not been, my lord, exhibited before the concerned tribunal, my lord, they must have said that since this man doesn't have any land document of his father or his own, my lord, he cannot be a, my lord, citizen of this country. Because if somebody is landless, my lord, the tribunal, my lord, never regards, my lord, his any, my lord, claim, my lord, before the concerned tribunal. Therefore, my lord, just to substantiate my claim that this land was, my lord, this land belonged to my father, my lord. In fact, by virtue of this land holding certificate, my lord, my father's name was wrongly written as Fakir, my lord. But the, my lord, Pata number and the dark number, my lord, it remains same, my lord. Therefore, my lord, I humbly, my lord, pray before your lordship, my lord. If your lordship, my lord, allows me, my lord, a little bit of chance, my lord, I'll be producing by next day, my lord. There are a number of, my lord, citations also, my lord, whereby not adjournment, my lord. I'll be, my lord, producing the, my lord, the other citations, my lord, by virtue of which, my lord, this honorable court has already, my lord, remanded, my lord, number of matters, my lord, before the concerned tribunal for reconsideration again, my lord. Since, my lord, there is no, my lord, clear-cut, my lord, finding, my lord, regarding and the observation regarding the voter list of 2005, my lord. The tribunal, the member of the concerned tribunal said, my lord, this can't be a conclusive proof of citizenship. How this can't be a conclusive proof of citizenship, my lord? That has to be, my lord, reason has to be, my lord, explained or given, my lord. Have I not become able to, my lord? My lord.
We are presuming just for the sake of appreciating things, we are just asking that, let us presume that your father had purchased the land, or he would have got the land by way of settlement. There are two options only.
Yes.
Third option is very rare. You will have a decree and then the land comes to your name by registration of a decree. The three modes. No. Now, to prove this, what would be the primary evidence according to you? These three things. Number one, either a decree or by way of purchase, by way of settlement. Question of inheritance doesn't come because you say that your father is alive.
Yes.
So therefore, what would be the primary proof of such transaction?
Now, if the land is purchased, my lord, a sale deed is required to be, my lord, produced, my lord, that I admit, my lord. These are technical aspects, my lord. My lord, I take the responsibility, my lord, it should have been produced, my lord. Since, my lord, from the bare perusal of the record itself, my lord, not only the, my lord, the chitta copy, my lord, but also the, my lord, the subsequent document, my lord, the land holding certificate. There has to be some land, my lord, in the name of father, my lord. Otherwise, this land holding certificate
Right.
would not have been issued, my lord.
See, what does a second question would be when you are referring to the certificate?
My lord.
As to what do you mean by what do you mean by a certificate? If I say that this is a landholding certificate,
My lord.
what do you mean by it? What according to you should it contain?
Correct. As far as, my lord, my understanding goes, my lord, it will contain, my lord, regarding the, my lord, the dag number and pata number and the area and the portion of land, my lord, which the person, my lord, is having in a particular area, my lord.
No, that is not the context in asking.
My lord.
The context in asking is whether that certificate itself is a primary evidence or it is a secondary evidence.
This is not a primary evidence.
Hmm?
Not a primary evidence.
Not a primary evidence. Okay. There's another thing which we had to ask you. Which document, according to you, in context of this Chitta and Jamabandi, is can we say that this Chitta is a original document, a primary evidence, so as to say within the meaning of it?
Regarding this chitta, my lord, yes, my lord, there has to have some background, my lord. Otherwise, this chitta will not come, my lord, directly, my lord. My humble understanding is that, my lord, unless there is a sale deed, my lord, there cannot be a chitta, my lord. It is a subsequent document.
That's not the correct decision.
My lord.
You see, this Chitta and Jamabandi, according to the Assam Land and Revenue Regulation, is 4 steps. First, there will be a draft Chitta, then there will be a Chitta, then there will be a draft Jamabandi, then there will be a Jamabandi.
Yes.
So Chitta is, according to the old school, which I had seen last many years back, was already that Chitta would always be made in pencil.
Yes.
So therefore, it's not a document of primary evidence. That is what I think. I may be wrong, but that's what I think.
My lord, this may be a, my lord, may not be a primary document, my lord, but the data and the, my lord, the records, my lord, that it has carried out, my lord, will come from the, my lord, sale deed only, my lord. Otherwise, my lord, this would not have been reflected, my lord.
Mr. Zaid Hamadlal, counsel for the petitioner and counsel for the respondents. Our court is concluded. Judgment is now. If you have anything to add, please give the thing to 10:30 morning to the courthouse.
My lord, I'll furnish it by tomorrow morning.
And with information to Mr. Sharma.
Yes, ma'am. There is another item, my lord, I'm bringing before your lordship, my lord, just to post this case, my lord. This is a fresh motion, my lord. Item 20, my lord. If possible, my lord will kindly take it up, or my lord will kindly take it up after my lord 20th, my lord.
We'll try to take it up because we are not taking up any hearing for the.
Yes, ma'am.
Item 7 and 8.
7 and 8, you are paying for adjournment. In item 7, you say, both says a represented, the prayer made by the representative, the matter can return today. This one, give a date. After, make it after. This one, then in item 8, you say, both says are represented upon instructions, Mr. N. Barma, and the counsel for the petitioner submits that the petitioner Abdul Noor alias Batul Ali has expired. However, he awaits receipt of the death certificate. Accordingly, matter stands adjourned today. List on suspense.
28th April.
Yes, item 9.
Item 9.
The admittedent is put it up for hearing. The records are available. We will not be able to take up hearing today. Process are represented. As the records copy is received, the court is inclined to do returnable forthwith without requiring any steps to be taken. Release the matter for hearing on immediately. In the first week of May 2026.
Week commencing.
Or make it week commencing 5/5/2026.
Item 10.
There are other three matters, 11, 12, 13, and 14. These are 2009 with LCR available. We are passing the same order. You are admitting it by hearing. 11, 12, 13, 14, same hearing. These are being listed in the week commencing 5th of May for hearing. Item 16.
Well,
We'll have to send it for forensic examinations. The signature in the Wakalatnama and this which were taken by the registry,
Right.
these are matching.
But
But the signature which is there in the
WS.
affidavit does not match.
WS it is not matching.
And even in the affidavit does not match.
No. There is a variation in WS and Okalatnama in affidavit also. But she appeared in my lord, before the vigilance officer.
Matching.
I-card also I have given identified my lord. মানে WS যেনেকে মাৰিছিলে কেইবছৰ আগতে তাতে বেয়া আছিল এতিয়া অলপ উন্নত হৈছে ভাল হৈছে My lord, my lord, what is looks here, my lord, that in WS, her signatures were very, my lord, not good, but nowadays her signature are developing, my lord. Yes, yes, big difference in WS. Yes, in my lord. Yes. My, what I inspect that our signature is developing now. In WS, it is very, yes, yes. My lord. And in in WS, it is totally different. Yes. Affidavit. Yes, my lord. My lord. My lord. But in WS, it is also totally different. My lord. My lord. My lord. No. My lord. My lord, then my humble submission will be with the liberty, my lord, then with the liberty, my lord. My lord. My lord, if I'm withdrawing with liberty so that my lord, this mismatch may be cured, my lord. My lord. My lord. I'm withdrawing with liberty.
Order dated, by order dated 25/2/2026, the court had recorded that on a visual comparison of the signature of the petitioner appearing in a written statement annexed to the writ petition, variance was noted in the signature of the petitioner in the affidavit filed in support of the writ petitioner. Full stop. Accordingly, pursuant to order dated 25/2/2026, the petitioner has appeared before the registrar within record vigilance and given her specific signature. Stop. It gives a visual impression that the signature in the affidavit does not match with the specimen signatures or with the signature in the written statement. Next, accordingly, the learned counsel for the petitioner seeks liberty to withdraw this writ petition with liberty to approach upon it. Where is considered in the law, is dismissed from the law with liberty as paid. The report of the registrar with record vigilance is to be kept in a sealed cover and made a part of the record.
Item 17.
Obliged, my lord.
Yes, item 17.
Lordship, the matter may be taken after some time.
Nineteen. Okay. Item 19. Yes.
The contested matter, opinion dated 30/10/2025.
Page.
In opinion, page 128.
But Mr.
F.A. Ahmed.
S.A. Ahmed.
F.A. Ahmed.
Also for the respondents. Page 128. opinion dated 30/10/2025. Asked by so-and-so in case number so-and-so, case number so-and-so, for which the petitioner was declared to be a foreigner post 25 in 1974. For this, three years person, police inquiry number is also there. For which the petitioner for not. Notice to deliver in COVID sector of according to this, or for the records, to be prepared for bail is opposed by the learned standing counsel for the FT matters. After considering the projection, 10 days time to take bail or rupees 5,000, is satisfaction or Superintendent of Police order, Sivsagar. Sivsagar or Soraideo?
Now, sir, I do.
Soraideo. You start for 4 weeks.
My lord, in this case, my lord, some delay has occurred, my lord, while preferring this writ petition, my lord. The impugned order was at page, my lord, 69, my lord. It was passed on 2nd of August 2019, my lord. Yes, my lord, I am praying before your lordship, my lord. This lady is, my lord, and her husband, my lord, is extremely poor, my lord. They're suffering from extreme poverty, my lord. They could not even, my lord, bear the litigation expense, my lord. So, yes, the certified copy of this order was obtained on 25th of my lord, July 2025. Even then, my lord, they could not prefer the writ petition on time, my lord. Therefore, my lord, at this stage, my lord, what I am praying before your lordship, my lord, lordship will kindly make, my lord, this much observation that, my lord, the lady shall not be, my lord, deported out of this country, my lord. I am praying, my lord, this much, my lord, before your lordship. He is extremely poor, my lord. My lord will kindly consider that part, my lord. My lord, sincerely, my lord, apologize for that, my lord. Yes. The impugned order was obtained, my lord, on 25th of, my lord, July, my lord. A certified copy that I'm admitting, my lord. Even then, my lord, she could not prefer the writ petition on time, my lord. But so far as her linkage and everything is there, my lord. There are a number of, my lord, witnesses who, my lord, adduce their evidence in favor of the lady, my lord. And she also inherited land from her father also, my lord. Therefore, my lord, yes, my lord. My lord will kindly consider, my lord, this part, my lord. She should have come, my lord, before your lordship, my lord, on time, my lord. But she is unable to come, my lord, because, my lord, her husband is also a daily wage earner, my lord. And they have, my lord, they could not prefer, my lord, the writ petition on time, my lord. Very sorry to, my lord, say, my lord, before your lordship, my lord. There are 16, I have, my lord, explain, my lord. Yes, my lord, page 18, para 16.
Minor.
Lord, I have a criminal writ petition, my lord. I have a criminal writ petition item 42, my lord. Can it be taken it up tomorrow, my lord, at 2 p.m., my lord? Some urgency is there. My lord, I am a, my lord, a cattle, my lord, I am operating a business, my lord, of cattle transportation by following the due procedure of law. my lord, my cattle as well as the mans are missing from my lord Gauhati police station in the district of Karbi Anglong, my lord. My lord, the statement I have made, my lord, at paragraph 8, my lord, page 10, that the petitioner has made repeated attempts to obtain information regarding the vehicles, buffaloes, and the detained persons, but the police of Gauhati police station have not provided any proper information till date. In fact, my lord. My lord. Same as the we left for double time.
Regarding 25 livestock, i.e. 25 buffaloes. Were seized by the police personnel at 30 police station or Karbi Anglong, along with 3 people of the firm of the petitioner. So it is predicted that the firm of the petitioner, namely Brahmaputra Goat
Supply.
all cattle supply livestock is having its office at Gosala Bazaar, ward number 5, Maligaon. And he has the necessary permission and access to carry on the trade of livestock and to transport them. Statement is made in paragraph 8 of the petition that repeated attempts from the petitioner has not been given information about the vehicles, buffaloes, and the detained persons. There are 3 persons and 3 detained persons. Accordingly, the petitioner has filed this habeas corpus petition. Next paragraph. Notice returnable on Friday, 20/3/2026. Extra copies of the petition, soft copy thereof, be furnished to the learned government advocate in course of the day.
Soft copy to the
Next paragraph. The next paragraph, in the meantime, in the event the vehicles, livestock, and people were taken into custody by the officer, by the police personnel from Gauhati police station, the officer in charge of Gauhati police station within bracket respondent is directed to produce the 3 detained person before the nearest magistrate.
Mine.
The respondent number 3 shall ensure receipt of instructions by the learned government advocate. Next paragraph. The learned government advocate shall transmit a downloaded copy of this order to all the 4 respondents to bring the order to the notice of the said authority. Next, based on 20/3/2026. Extra copies
My lord,
Short time-
I'll serve soft copy as well as hard copy, my lord.
In course of the day to day.
My lord. Highly obliged.
May please, your lordship, item 43, lordship. This is a review application, lordship. In this case, we failed to obtain the SLP from the Honorable Supreme Court, lordship. Lordship, here I have taken one ground that after accepting written statement, no date for lordship filing evidence was given to the petitioner. So may I pray your lordship may call for the record, and in the meantime,
No, because if the matter is pending before the Supreme Court, then we can't touch it.
no, lordship, that was disposed of. SLP was dismissed, lordship. Page 68 and 69.
We take it up tomorrow.
Lordship, day after tomorrow then.
Because we.
May I pray to fix it at 2 p.m., lordship?
To make a mention, in our orders, we are not saying 2 p.m. or 1 p.m.
Lordship,
In the morning, to remind us.
lordship, obliged, lordship,
Positive time matter could not be taken up for the responsibility.
obliged, lordship.
Yes,
May it please your lordship, item number 24, there is an interim order, lordship, that may kindly be continued.
22.
24, lordship.
So we are taking it up on day after tomorrow.
Tomorrow there is some difficulty on part of my senior, lordship.
Day after tomorrow.
Day after tomorrow, there is some difficulty.
It is in
Right, this
Next week.
next week, lordship, on, after 25th, any date,
25th.
lordship.
Positive time matter could not be taken also as a present. This from 26th, 2026. Interim order of Archivist and extended.
Much obliged.
Correction of the most title of we can't do it because my brother has a bench. This is bond on Nalbari and furnished bail bond of rupees 10,000 with 2 solvent sureties. Before releasing the petition on bail, the Superintendent of Police Border Nalbari shall obtain the biometrics of the iris of both eyes. They will also obtain necessary information and documentation as per rules. Steps shall be taken by the Superintendent of Police Border to have the petitioner, Dilawar Khan, released from jail within 2 days from the date of receipt of a certified copy of the order. Bail is granted on the following conditions: not to leave the territory of Nalbari without permission of the Superintendent of Police Border Nalbari. You will have to appear before the Office of Superintendent of Police Border Nalbari on 1st, 10th, and 20th of every English calendar month at 11 a.m. You will also appear before the Foreigners Tribunal Nalbari on each and every date unless exempted. During bail, you shall not indulge in any criminal activity or offense and shall not indulge in any anti-India activities. If such act comes to the notice of the competent authority, it would be open to them to move the Foreigners Tribunal Nalbari for cancellation of bail. If the petitioner remains unrepresented in the proceedings of the tribunal will be it will be permissible for the tribunal to pass appropriate orders and cancel bail granted by this order and pass orders to take petitioner into custody or to treat the petitioner as absent on call and proceed with the proceedings. If any restraining order is passed by the competent authority, the same shall prevail over this order. So the challenge to your Nalbari FT case number 56 of 2025 is rejected. Inform G. Shapa and government advocate.